USPAP, page 226, record keeping rule continued. Number 87, appropriate work file retention and access arrangements. Question: USPAP requires an appraiser who does not have custody of his or her work file to make appropriate retention and access arrangements. What does this mean? Response: the record-keeping rule states in part, an appraiser must have custody of the work file or make appropriate work file retention, access, and retrieval arrangements with the party having custody of the work file. Bold added for emphasis. There are a number of ways an appraiser who works for or with another party can ensure that the assignment work file is retained so that the appraiser may access the work file. The following is a common example. An appraiser and his employer or colleague agrees that the work file will remain in the employer's or colleague's custody for the duration of the requisite retention period, and that the appraiser will have access to the work file. In practice, having such an agreement in writing could prove beneficial to all parties if access and retrieval arrangements are subsequently called into question. Number 88. May access to a work file be denied? Question: two appraisers perform an appraisal assignment together. Appraiser A retains the work file, and appraiser B has made access and retrieval arrangements. Are there any conditions under which USPAP allows appraiser A to deny appraiser B access to the work file? Response: yes. USPAP does not set conditions for work file access and retrieval. However, the record-keeping rule states an appraiser having custody of a work file must allow other appraisers with work file obligations related to an assignment appropriate access and retrieval for the purpose of submission to state appraiser regulatory agencies, compliance with due process of law, submission to a duly authorized professional peer review committee, or compliance with retrieval arrangements. Bold added for emphasis. In this scenario, if appraiser B is seeking access for purposes outside those specified, access may be denied. Number 89, access and retrieval of work files. Question: I am an appraiser in a large firm and assist several of the senior appraisers in appraisal research, analysis, and report preparation. In a recent USPAP class, the instructor said that associates must have either copies of their work files or an arrangement with their employer regarding access to the work files for appraisals on which they provided significant assistance. Does that agreement have to be in writing? Response: no. USPAP does not specify whether the access and retrieval arrangements you must make be in writing. The record-keeping rule states an appraiser must have custody of the work file or make appropriate work file retention, access, and retrieval arrangements with the party having custody of the work file. This agreement can be either written or oral. However, there is less chance for a misunderstanding about the agreement if it is in writing. Page 227. Number 90. Signed certification in true copies. Question. The record-keeping rule states, in part, the work file must include true copies of all written reports. Does a true copy have to include a signature on the certification? Response: yes. A true copy is a replica of the report sent to the client. Any signatures that were affixed to the original report must also exist on the copy of the work file. Number 91. Creating a work file after report delivery. Question. I was recently told that USPAP allows appraisers to wait and create a work file after the report has been delivered to the client for an appraisal or appraisal review assignment. Is this true? Response: no. The record-keeping rule states a work file must be in existence prior to the issuance of any report or other communication of assignment results. A written summary of an oral report must be added to the work file within a reasonable time after the issuance of the oral report. Bold, added for emphasis. It is advisable to create a work file as soon as an agreement between an appraiser and a client results in an assignment. Number 92. Is a transcript required for oral report and testimony? Question. Is a transcript of an oral report or testimony required for the work file when an appraiser testifies about an appraisal assignment? Response: no. There is no absolute requirement to have a transcript of the appraisal oral report testimony. The record-keeping rule requirement is for the work file to contain summaries, which are typically prepared by the appraiser, or a transcript. In cases where summaries are retained, a transcript is not required. Number 93. Is a transcript required if a written appraisal report was prepared? Question. Does the requirement to have a transcript or summary of testimony apply if the appraiser has a written appraisal report and testifies only to the information contained in that report? Response: yes. A transcript or summary of the testimony must be included in the work file when the appraiser testifies about a written report, while the report that is the subject of the appraiser's testimony must also be included in the assignment work file. It does not replace a summary of the testimony. Number 94. Record-keeping requirements for oral reports and testimony. Question: does the requirement to have a transcript or a summary of the appraiser's testimony apply only in assignments when an appraiser provides an oral report? Response: no. The requirements identified in the record-keeping rule apply to both oral reports and testimony in an appraisal or appraisal review assignment.